Hi, everybody. Welcome back. Looking forward to actually going over chapter 3 with you from the business law textbook. As always, I hope that if you guys have any questions about the material in any way, shape, or form, feel free to email me at either my Doral email that's available to you in the syllabus on the course page in Schoology, or my Matter Lakes email, which is rmedina@matterlakes.org. So let's get to it because this chapter is a pretty long one. And I want to make sure that we get through it pretty efficiently and hopefully in a manner that you guys can understand everything that we wanted to talk about. So it starts off with trying to explain what the process is of litigation and what litigation means. And litigation is simply the process that leads to a trial, everything that involves a trial and the steps that lead to a trial. Usually that's a term that we reserve uh, and it's known as litigation. Okay. Now, if you do go through litigation, what you're basically saying is you're going to hopefully go before an impartial judge or an impartial jury to decide the winner of an issue that you have with somebody else, if it's a civil case. And if it's a criminal case, the same logic, except for the fact that it now involves the state. Now, there are different steps that people may take to try and avoid litigation. And that's something that we'll cover later on in this chapter, I believe, if not later on in this course. Let's assume for the moment, though, that you are on the track of having to appear before a judge in a courtroom and having to appear before a jury. One of the most common questions that students always ask is, well, what does the judge do? And what does the jury do? Why are they both there? Why are these entities there? And so I wanted to start off by trying to paint the picture for you so that you have an understanding of how a courtroom works and what the process is within, or what each group or person within a courtroom does. So the first, the party that starts a civil lawsuit is known as the plaintiff. This is the person who claims they have been wronged in some way, shape, or form. Okay. There is a person who claims that they have been wronged in some way, shape, or form, and they are known as the plaintiff. We abbreviate the plaintiff when we're writing notes very quickly with the pi symbol. I know many of you are familiar with pi only because you believe that it's 3.14, and while that is also true, pi actually stands for the Greek letter p. And in law, when we use pi, you are using the letter pi, p, for plaintiff. It's a shorthand that we use to abbreviate for plaintiff. So the plaintiff is the party that starts a civil lawsuit, and they are the ones who sue the defendant in a civil case. Usually they're trying to recover something that is known as damages, which we've already discussed, involves money. Now, in a criminal trial, the party that starts the trial or the party that starts the litigation process is known as the prosecution or the state, and they represent the people of the state or federal government. And just like how in a civil case, the person who's being sued is known as the defendant, in a criminal trial, the person who is being accused of a crime is also called the defendant. So the defendant is a term that's reserved for both types of cases. Now, this chapter involves basically a course in law school that is known as civil procedure. So this chapter is a little bit of a doozy because they try to condense a pretty complicated topic within law that is covered in 1 or 2 semesters worth of law school to 1 chapter. So it's a little bit tricky, but we'll get to it. One of the things that I want to encourage my students to realize is that when they think of a lawsuit, many times they think of one person suing another person. And that's, while the most common lawsuit, by no means is it always one person versus another person. In fact, many times you're going to see multiple plaintiffs suing one defendant, or multiple plaintiffs suing multiple defendants, or one plaintiff suing multiple defendants. And now all that may happen. Now, each time that a plaintiff states or asserts that the defendant wronged them, we call that a claim. A claim is simply a separate violation of law. So if I am being sued for, I don't know, if I'm being sued for assault and battery because I punched 10 different people, well, there would be 10 different lawsuits from those 10 different individuals or 10 different claims from those people, 10 different plaintiffs, suing me, the defendant, for each separate instance where I where I punched them and they're trying to recover money for me having punched them. So a claim is a separate violation of law. Now, when you are sued, one of the questions that people always ask is, first off, should a lawyer represent themselves? The answer is no, because you are biased, and you should never try and represent yourself when you are emotionally compromised, when you are vulnerable. You should hire somebody to represent you if you're a lawyer. But a lawyer can represent themselves. Even you, as a person, may choose to represent yourselves once you are an adult. And a person who chooses to represent themselves is known as a pro se litigant. We never recommend that you do this because you are going to be held to the same standard as a lawyer, and your lack of knowledge is not going to be excused if you make mistakes in your trial. And obviously, the higher the stakes for that trial, the more likely you are to want to actually go ahead and get a lawyer. Now, if you're talking about fighting a traffic ticket, I recommend still getting one because it saves you the time of having to show up in court and seeing if you can try to get out of a ticket. But you can sometimes go and do it yourself. I've done it myself even before I was a lawyer. But you're hoping in those instances that the cop doesn't show up, and if the cop doesn't show up, the case is eliminated, dismissed. But if the cop does show up, now you've got to try to provide evidence as to why you shouldn't have been given that ticket. And that's typically something you would want a lawyer to do, or try to have a lawyer argue on your behalf on what the consequences should be for you having broken that ticket. Broken that traffic law and received the ticket. So then the next question is, well, what does it take to be a lawyer, and how do lawyers work? Well, lawyers are going to be forced to go to a 3-year program. Usually it's a 3-year program. Sometimes you can try to do it within 2.5 years, where you go through law school after you have gone to college. So in the United States, you graduate from college with your college degree, and then you take an exam that's known as the LSAT. And then you go through 3 years of law school. It is highly controversial whether 3 years of law school are necessary. It's my opinion that they are absolutely not necessary, more than maybe 1 or 2 years, and that in some instances you might be able to even get the experience without having gone to law school. But law schools really exist so that they can force people to pay for the law school, so that they can make it more expensive and make money, and also to make the process of becoming a lawyer more challenging, so that there are fewer lawyers, so that we can hire more, so we can charge more because there's less of us in relation to people out there. However, you graduate law school with a degree that's known as a Juris Doctorate degree. It's abbreviated as a JD. And then you take a bar exam, where basically what that exam does is it grants you the license to practice law in the state that you want to practice law in. So I am allowed only to practice law in the state of Florida because my bar license is only from the state of Florida. If I wanted to practice law in Indiana, I'd have to travel to Indiana and take that state's bar exam and pass it. However, once I have graduated law school, I have the ability to take the bar exam in as many states or as few states as I'd like to. And I do know some people that have taken a bar exam in multiple states. I've had friends of mine who have taken the bar exam in North Carolina and Florida, New York and Florida. Usually it's people who say that they no longer want to live in Florida and they move to another state and they choose to take the bar exam a second time. Now, lawyers are required to behave ethically. We have a code of conduct that we are required to abide by, and that is set by the state Supreme Court of the state where we want to practice in. And one of the most important responsibilities that we have is what is known as the attorney-client privilege. The attorney-client privilege simply requires us to keep any conversations that we have between ourselves and a potential client or an actual client secret. with few exceptions. So for the most part, we are required to always keep our mouth shut if somebody comes to us and asks us for legal advice. We're not allowed to talk about it. Even after the person has died, even if the person has, even after the person has died, even if it's 100 years have passed and I'm still alive, no, I'm always required to keep silence on these cases. I am allowed to talk about them with other lawyers that are in my law firm. I am allowed to talk about it with my paralegals, and obviously the attorney-client privilege would also extend to them. The only exception, or one of the few exceptions, where I am allowed to break the attorney-client privilege and actually discuss with somebody with somebody other than my client, what they have told me, is in the event that the client is threatening to hurt themselves or threatening others. So if I have a client who tells me that they plan on killing somebody in 2 or 3 days, then by law, I am required to tell the police that the client has told me this, and it is not considered a violation of the attorney-client privilege. Similarly, if, and I know that they mentioned it somewhere in here, yeah, there we go. If a client wants to try and lie under oath, and I know that they're lying under oath because they told me what the truth is, I am required by law to remove myself from the case if I cannot get the client to not testify. So it's not like I can tell the judge or the jury about what it is that they have told me. I can't reveal the truth, but I can remove myself from the case because I am not allowed to promote knowingly lies under oath. And as a lawyer, I am allowed to. I owe my clients what is known as zealous advocacy. That means passionate advocacy, passionate lawyering, but it must be done so within certain boundaries. I cannot exaggerate the truth. I cannot try to make up arguments that have no legal reasoning behind them. I cannot try to. There are rules within which I must operate as a lawyer. So that's my job as the lawyer. And obviously the other side would also have the same obligations, right? So each side hopefully is represented by a lawyer, the plaintiff and the defendant if it's a civil case, the state and the defendant if it's a criminal case. That brings me now to my next question, which is what is the role of the jury? And the jury's purpose is to figure out the facts. The jury's purpose is try to figure out who said what, when, why. And there are two types of juries. The first is what is known as a grand jury. A grand jury deals with criminal cases. So they're only going to be summoned or brought in for criminal cases. And what the purpose of the grand jury is to simply decide whether probable cause, which means whether it's probable that a crime has taken place and whether it's more likely than not true that the defendant has committed that crime. If the grand jury says yes to both of those questions, then what ends up happening is the criminal trial will actually begin. So a grand jury's outcome is not by any stretch of the imagination a determination of the actual guilt or non-guilt of the defendant, but rather simply whether the grand jury decides or believes that if the facts are true that the state is claiming, whether there is enough evidence to suggest that it is more likely than not that a crime has taken place and that this specific defendant that the state has charged is the person guilty for having committed that crime. So the purpose of the grand jury is to try and prevent prosecutors from being too bullyish, too much of a bully, and try and arrest people and indict them and put them in jail for several months without first having had a group decide whether there is even any reason to have these defendants possibly serve in jail. Okay? So that's the purpose of a grand jury. And grand juries typically meet for extended periods of time and they'll listen to different types of cases. So they'll make decisions on multiple cases as to whether the state has or has not provided enough evidence for there to be an actual trial. Now, once the grand jury has decided that there is probable cause and we are actually allowed to proceed and move the case to a criminal trial, a petite jury is going to be called. And what a petit jury does is what you guys typically have seen in movies, where you have a panel normally of about 12 people. Sometimes it can be some as low as six, but usually we think of them as 6 to 12. And a jury is going to listen to the actual case, that they're going to sit there for the entire trial, and they're going to decide the outcome of the case, guilty or not guilty. If it's criminal, if it's civil, there's not going to be a grand jury. It's just going to go straight to a petit jury, and then there's going to be uh, the determination of whether the defendant is liable or not liable. So that's the purpose of the petit jury, to decide the guilt or not guilt, apply the law that the judge has given to them to determine whether a person has broken the law or not. Right? Now, it's important that you guys understand that the purpose of juries is extremely important. We draw juries from voter registrations, from from driver license registrations. It's extremely important for us to value the purpose of juries. There are rules in place to protect citizens from being overly burdened from the concept of juries. We've also have rules in place to try and make sure that the juries that we do call into existence are fair. So we try to make sure that our juries are not drawn from a specific ethnicity, from a specific um, uh, gender, from a specific race, from a specific socioeconomic class, but rather we try to do our best to randomly pick our juries from random segments of the population so that we can have a fair representative sample of the jury deciding the outcome of the case. There are groups who are automatically exempt from jury duty, and these are military members, so members of the Army, Navy, Coast Guard, Air Force, cops, firefighters, and public officers. Lawyers are not necessarily going to be automatically exempt, but they're usually never going to call a lawyer in to be a jury because we have too much power and we could influence the jury too strongly. All right. From there, we're going to move on to what is known as standing. Now, standing is a constitutional requirement, and what standing means is that courts cannot give advisory opinions. Courts cannot give advice on anything. The purpose of a trial, the purpose of a court, requires that a plaintiff or the state listens to actual problems, actual cases, not hypothetical ones. So you're never going to present to a court a possible hypothetical of what happens if Joe meets Jane and Jane does X to Joe and is unfairly punished by law Y. That's a hypothetical. Courts are never going to be brought in for hypotheticals. Courts will only listen to actual cases. And in order for there to be a case, a party has to have evidence that something's actually happened, that there's a case that's affected them in some way, shape, or form. And that is what is known as standing. Standing. You cannot bring a case too early. You cannot bring the case too late. And it has to actually affect the party that's bringing the case, whether it's a civil case or a criminal case. The party has to be negatively affected. In a criminal case, the government is negatively affected, or the state representing the people are negatively affected every time a defendant breaks a criminal law. That's how they have standing. In a civil case, the plaintiff has to show that they are negatively impacted by whatever it is that the defendant they claim has done. So that's the concept of standing. From there, we talk about something that is known as subject matter and personal matter jurisdiction. Subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction requires that the court has the ability to have lawsuits or court cases before it that deal with the particular subject that the plaintiff or state have brought up. Let me give you an example of this. There are such courts known as bankruptcy courts. You cannot bring a paternity issue, an issue involving family law, to a bankruptcy court because bankruptcy courts do not have the subject matter jurisdiction to listen in on cases involving family law issues. They only have the power to listen to issues involving bankruptcy court. So that is, in simple terms, what subject matter jurisdiction means. Personal jurisdiction, on the other hand, is the power that a court has to force a party to appear before a judge, to appear in court. And the requirement is that in order for a court to be able to have the power to enforce personal jurisdiction, the litigants or the parties to the trial have to have some minimum contact, at least some basic contact with the state where the case is filed. So what this prevents me is from being forced to go to Alaska for a lawsuit where I bought a watch here in Florida and the other party has now moved to Alaska and now they're trying to force me to automatically go to Alaska. That's very difficult. There's going to be rules to protect me from that. Okay. Now, personal jurisdiction is also a constitutional requirement. There are going to be certain instances where there are going to be long-arm statutes. What those are called basically is those are procedures where a defendant may be required to appear to a court from another state, but that's more challenging to do. It's really inconvenient for a defendant to be required to travel to another state to defend themselves from a trial. There's going to be certain terms that we're going to have to learn. Service of process. This is the process through which a defendant is notified that they are being sued. You must correctly follow the process of serving a defendant in order for that defendant to be required to show up in court. Otherwise, they're not required to show up in court. And there are actual rules in place that tell you how you may that show the requirements for a defendant to be informed of the reality that a lawsuit has begun against them. Okay. Usually what it's going to require is a copy of the notice to appear before the judge, and it has to be normally delivered personally to the defendant or the defendant's representative or agent, like a lawyer. Okay. If it's a business that you're suing, and yes, businesses can be sued, then the service of process is usually delivered by sending a copy of the notice to appear to a registered agent, which means a representative that works on behalf of the company. Usually service is going to be more challenging with individuals. Now, I really like this chart because it gives you the basis for personal jurisdiction. What this means is these are some of the ways that a court may require an individual to show up before their court. One of the easiest ones is consent. If I agree to get sued in Georgia and I agree that I'm going to go travel to Georgia to defend myself in a lawsuit, there's no problem. I have granted through my consent personal jurisdiction to the judge, and that's and then the judge from the state of Georgia. A second way that a judge may acquire personal jurisdiction is if the defendant lives in that state. So if I live in Georgia, well, great, I can be sued in Georgia. Third way that personal jurisdiction may be given is if the defendant is served a summons and complaint within the state. That goes hand in hand with residence. Last but not least, the long-arm statute. These are the circumstances in which a defendant may be required to appear before a judge in an out-of-state courtroom. And there's going to be two different ways where that may happen. Number one, the defendant business or the defendant individual was involved in an issue with another state. So, for example, I had a traffic speeding ticket in Utah 3 years ago. Okay, well, I had an issue in Utah, so I may be required to appear in Utah because I messed up in Utah. So they can force me to show up in Utah to defend myself if I want to challenge that lawsuit or if I want to challenge that ticket. That's one example. And the opposite direction may also take place. What that means is, it's tricky to explain this, but if, I don't know why they phrase it like that. That's basically long-arm statute. I'm not going to go make it more complicated than that. So that's usually how long-arm statutes work. I had to have had some contact with the out-of-state business or entity or individual that's suing me to force me to be able to show up in that courtroom and defend myself. Once we move past subject matter jurisdiction and personal jurisdiction, we have the actual concept of venue. Now, venue was something that was very tricky for me to understand when I was in law school, nor is it because I wasn't paying attention to my law school classes. But venue now is talking about what the specific uh, location of that court should look like. So uh, it's not enough to sue me in Utah or for Utah to actually bring me to court. There has to be, the venue has to be appropriate, which means we have to actually put me in the correct city, right? Where I actually messed up. And that's the concept that is known as venue. The idea that um, I need to be sued in the area where the wrongdoing took place or where I live. That's correct venue. And there can sometimes be different correct places for venue. All right. Um, if Koala Kickball gets sued and we have some business in Broward County and some business in Miami-Dade County, we could potentially be sued in either Broward County or Miami-Dade County because venue would be proper. Probably more proper if, depending on where the wrongdoing took place. So if we messed up or the defendant claims we messed up in Broward County, perhaps venue is more appropriate in Broward. Although you could make the argument that venue is more appropriate in Miami-Dade County if the defendant and myself both live in Miami-Dade, even though the incident took place in Broward. So there could be two potentially correct answers as to what the correct venue looks like. All right. That takes care of venue. Now let's analyze the actual timeline. It's funny that they actually cover this in one timeline, in one picture. Let's look at the timeline for how a trial moves. Okay. The first document that starts a lawsuit is what is known as a complaint. A complaint is started usually by the plaintiff, right? And a complaint is a legal document that states who the parties are, so who the plaintiff is suing, the facts of the case, meaning what the plaintiff believes the defendant has done and what happened in the case, and the laws that the plaintiff states or believes that the defendant has broken. The end of a complaint ends with what is known as a prayer for relief. A prayer. Why a prayer? It's not a religious prayer, it's a request. A prayer is another synonym sometimes for a prayer is a request. So a request for relief, a request for a solution, meaning the prayer for relief is going to outline what the plaintiff believes they should receive from the courtroom for the case. It could be that they think they're entitled to $10,000 from the defendant. It could be that they want the defendant to return to them a home. It could be different things. But that's what the prayer for relief is, and it's going to be found within the complaint, which is, again, the first document that kicks off officially a lawsuit. So the complaint is going to be submitted to a clerk of the court where the plaintiff wants the lawsuit to be heard. And assuming that there are no issues of the venue or in subject matter jurisdiction or personal jurisdiction, the clerk, well, actually, even if there is, the clerk will still issue something that is known as a summons. What is a summons? A summons is an official notice that a lawsuit has been filed with the court, and the defendant has an obligation to defend themselves in that courtroom. Okay? So to be effective, the defendant must be served with the summons and a copy of the complaint so that they know what they're being sued for and they have time to hire a lawyer if they want to represent themselves, to represent them in the case. All right? Now, if there are if there are many plaintiffs in a case, there may be what is known as a class action lawsuit. You guys have all seen mesothelioma, whatever it's called, late at night on TV commercials where they've told you if you or your loved one has been a victim of blah, 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 what they're telling you is something that is known as a class action lawsuit. And a class action lawsuit is when, in order to save time and not have 5,000 trials against the same defendant by 5,000 individual plaintiffs, all those plaintiffs unite under one case, under a group of leaders, to try and go ahead and sue the defendant or the defendants if there are multiple defendants. Now, there are certain criteria that must be met for a class action lawsuit to exist. There are so many, number one, that there are so many plaintiffs. There's such a large number of plaintiffs that, number two, it is impractical to have multiple different lawsuits. And that all these plaintiffs have similar problems of fact and law that are negatively affecting them, that they can actually unite. And number four, they agree to follow the lead of the plaintiffs who initially started the case. Maybe there's 5 or 6 of them, and that they agree to unite themselves to their efforts and let those lead plaintiffs serve as the leaders to try and represent all the different members who belong to that class. And this is what is known as a class action lawsuit. Okay. Now, let's step away from a class action lawsuit because I don't know why they mentioned it here, and let's continue with the actual flow chart that we've been looking at so far here, right? Of what the litigation timeline looks like. So there's a complaint which states what the defendant has done wrong in a civil lawsuit and what the plaintiff requests the judge make the defendant do to repair the damages that the defendant has supposedly done. There is the summons, which is when the plaintiff provides the defendant notice through the complaint and the notice of action, that the defendant, a copy of the complaint and the summons, that the defendant is being sued. So the summons is basically where the defendant is informed of the lawsuit. The answer is the third step of our litigation timeline. And the answer, like you would imagine, is usually done within 30 days of when they receive the complaint or when they receive the summons. And it is a paragraph by paragraph response to the plaintiff's complaint made by the defendant, where the defendant admits, denies, or says that they are without knowledge as to the different issues that the plaintiff has said. Now, sometimes people ask, why would you admit to anything? Well, the first paragraph, usually complaints are listed into paragraphs, or really they're like sentences many times. Like a paragraph may have 1 or 2 or 3 sentences, depending, like different topics. The first sentence may be that the defendant bought a watch, the defendant sold the plaintiff a watch. Well, you're not going to deny that. You're going to admit that if that's something that did happen. That may not mean you did anything wrong. It just means you sold somebody a watch. So you're going to admit to the facts that you believe are true. You're going to say that you don't know about certain facts if you don't know if they're true. And you're going to deny certain facts if you say that they're not true. And that's the concept of an answer. All right. Aside from responding directly to the paragraphs made by the plaintiff, the answer is also going to contain what are known as affirmative defenses and counterclaims that the defendant wants to pursue. Affirmative defenses are defenses that the defendant must prove. Usually in a civil lawsuit, we've talked about this before, the defendant doesn't have the obligation of proving anything. The plaintiff has the obligation of proving everything, with the standard that is known as beyond a preponderance of the evidence. Well, in certain cases, if you're claiming that you did do something, you have the obligation of actually convincing the jury by a preponderance of the evidence that you did do what you claimed you did. Okay, that's known as an affirmative defense. So an answer may contain affirmative defenses, and it may also contain something that are known as counterclaims. What are counterclaims? These counterclaims are when the defendant is actually suing the plaintiff in return, saying that the plaintiff has somehow wronged the defendant. And so counterclaims are going to be found within the answer as well. Oh, trials can be a lot of fun. Now, the complaint and answer are known legally as the pleadings. So you hear lawyers talking about pleadings all the time. Well, pleadings are the complaint and the answer. The complaint and the answer. After that, litigation typically moves into what is known, yes and no, it's not 100% accurate. There's going to be other things that can happen in between here. I'm going to skip them because I don't care about them too much. Really, the next step that I care about is what is known as discovery. And discovery is the process where each side finds out what evidence the other side has in the case. In the United States, we have the adversarial system. We've discussed this before already. And the adversarial system requires sides to exchange information that they have that is relevant to the case. Now, not all information is allowed to be exchanged. For example, some of the information that you tell your attorneys, or any information you tell your attorneys, protected under attorney-client privilege. The other side is not allowed to have that information with them. But if there are contracts, or if there are receipts, or if there are emails that are between the plaintiff and the defendant, or people that are going to be involved in the case, that will be subject to discovery, which means that in discovery you discover, that's why it's called discovery, you discover what the other side has and what they plan on using against you in a trial, so that both sides have an idea of what the trial looks like. Okay, so even if something cannot be used in trial, it might still be allowed in discovery. So perhaps some of the evidence that one side gets from the other side was illegally obtained, which means that it shouldn't be allowed in the trial. It would still be allowed for discovery purposes to be exchanged. So discovery rules are very broad, so that both sides can become as familiar with the case as they possibly can. Okay. Now, those of you that are interned for a judge or want to intern for a judge, a lot of times what they're going to do is have you work on these discovery documents. And there are different types of discovery documents. I worked with a lot of these. I actually did all of these. A request for admission is when you are asking the other side to admit to specific facts or claims. So, for example, if you're asking them, hey, I want to confirm that your legal address is this, or that I want to confirm that your cell phone number is this, that's a request for admission. You're asking the other side to admit to certain facts so that you don't have to go and try to find out later on in the trial whether those facts were true or not. An interrogatory is a series of questions to the opposing party regarding the nature of the claim. So interrogatories are when you ask the other side to basically tell you, to answer different questions that you think are going to be relevant to the case. If I tripped and fell at Walmart and I am suing Walmart for my injuries, well, Walmart has the right to give me an interrogatory and have my lawyer work with me through an interrogatory, where I document, or where I write down in a document, in an interrogatory, what it is that I got injured, or where the injuries took place and how I got injured and which doctors I went and spoke to and who gave me treatment, so that then Walmart can continue doing their own investigation. And that would be known as an interrogatory. A request for production. I must have done 100 requests for production as a lawyer. I did many. A request for production is when you provide the other side a written document where you ask them to give you documents and evidence that are relevant to the lawsuit. So this is now actually when you demand the other side to give you copies of documents, give you copies of emails, give you copies of contracts, give you copies of health insurance claims, give you copies of medical records, give you copies of health bills, of insurance bills, of this is when this production exists, request for production. And I think usually sides are given, I forget if it's 45 days, I believe they're given 45 days to give all the requests for production that one side gives. Let me take that back. I'm sorry. If I submit before a judge a request for production and I give it to the other lawyer has 45 days, I believe. It's either 45 or 60, I forget now, to return their whatever I asked, to give me a copy of whatever I asked. Now, you can file for extensions to discovery, but that's usually how that plays out. Requests for production. And both sides file requests for production. Okay, it's not just the plaintiff, the defendant may also file requests for production, and so forth. I'm trying to see what the days are. Days. Yeah, it's it can be actually it's 30 days to 45 days depending on the situation. So that's when the request for production must be returned. But you may file for extensions, and usually they're granted. And then last but not least are depositions. Depositions are sworn testimonies that are done of potential witnesses that you hope to use in trial outside of the courtroom. So it's a little bit more informal, even though You cannot lie, because if you lie, you're committing perjury, which is a crime. But the nice difference is that you're not in front of the judge and the jury, and they can be in a law office. Normally that's where they're done. And you have a court reporter to write everything down that's said word for word. And it saves money because the depositions are more, lawyers are going to charge less money for having to go to court. I'm sorry, for having to do a deposition than having to go to court. So depositions are a bit of a cheaper way to try and get sworn evidence from the other side or for potential other witnesses regarding a trial. All of these are types of discovery. All right. Now, there are also documents that are known as motions. Okay. Motions are requests for the judge to rule on an issue or a claim. All right. Now, there are different types of motions. The first one that we're going to talk about is a default judgment. This is when the plaintiff asks the judge to say that to legally side and with the plaintiff and close the case against the defendant because the defendant refused to show up in court. Okay. That's known as a motion for default judgment. The other side defaulted, the other side quit, didn't show up, and the plaintiff wants to win everything they asked for, and the judge usually will grant it if the defendant didn't do any paperwork at all or show any evidence that they wanted to actually present themselves in court. The second type of motion that exists is a motion to dismiss for failure to state a claim. What this means is that even if all the facts that the plaintiff claims were true, the behavior that the defendant has done has not broken any laws. And this is an example of filing a motion for failure to state a claim because you have not been able to state a claim that the defendant has actually broken. A law that the defendant has actually broken. It's important for you to remember that all laws have something that are known as statutes of limitations. And what this requires is, and I don't know why they mention this here, it's ridiculous that they mention it randomly here. Statutes of limitations, this is just a random topic, but statutes of limitations are laws limiting when a lawsuit may be brought up from the moment the problem first took place. And there's going to be a year's restriction so that I cannot get sued for something I did 25 years ago. So we've talked about two motions so far, a motion for a default judgment, a motion to dismiss for failure to state a claim. A third type of motion is motion for judgment on the pleadings, and this is filed before discovery. And what this says is that if there are no factual decisions that the jury would have to decide, meaning that both sides agree on the most basic facts, okay, then if this is done before discovery, remember that. If there are no disagreements on the facts, then the judge can make a decision as a matter of law as to whether the defendant has broken a law or not. Because there's no point of a jury. The jury doesn't have to decide what the facts are because both sides agree on what the facts are. There's no need for discovery. Both sides agree on what the facts are. And the judge can just decide what the outcome of the case is based off of what they have already received. This is known as a motion for judgment on the pleadings. The judge is judging on the pleadings, meaning the complaint and the answer. Very similar to a motion for judgment on the pleadings is what is known as a motion for summary judgment. Now, a motion for summary judgment asks the judge to enter a decision in favor of a party instead of trying the case. This takes place after the summary judgment, after discovery. So, typically, it's kind of very similar to a motion for judgment on the pleadings in that, remember when we talked about the judgment of the pleadings, there were no facts after the pleadings that the sides disagreed on. So therefore, you're trying to end the trial and have the judge decide one way or another. Motion for summary judgment is the same, except that instead of it being done after the pleadings, it is done after discovery. All right? However, defendants usually win a lot more motions for summary judgment than plaintiffs. Usually plaintiffs are not going to win summary judgment motions. And these are summaries. There's a chart again of all the different types of motions that we've talked about. By the way, there are many other motions out there. There are motions, but I'm not going to get into them. These are the ones that we're going to stick with because it's what the book uses, and I already think they're being very thorough with what they're talking about. Now, when a party wants to provide evidence to support a motion, they may submit what is known as an affidavit. An affidavit is a written statement that's made under oath, and it serves as evidence supporting what one side is saying in a motion. So affidavits are frequently used, particularly for filing motions for any one of these motions. All right. Okay. Now, once discovery ends, the case moves on to trial. Now, typically, well over 90% of cases are resolved before getting to trial. So a lot of times people think that everything that happens when there's a lawsuit that begins goes to trial. The reality is most of the times the parties try to resolve their differences before getting to trial. It becomes a lot cheaper. They don't have to spend as much money on legal fees. And so usually the parties are going to try to resolve their differences before reaching trial. In the event that they do reach trial, and this is meaning that there's already discovery has taken place, we've already had our pleadings, we've already had our motions, we've already had discovery. So we are in the very end of this stage, trial stage. Okay. Well, in order for those, once we get to the trial stage, what the first step is going to look like is what is known as the process of selecting a jury, which is the voir dire. Now, voir dire is the process where you begin having jurors fill out written questionnaires that ask the jurors to identify what their work is, if they have any conflicts of interest, if they have any biases. And then from there, the lawyers are going to quiz potential jury members to decide whether they have biases that would negatively impact their ability to serve in the jury. So there's going to be a fight as to who's going to be in the jury. We're going to determine the most fair jury possible for both sides, and to make sure that individual jury members that are actually members of the jury are not biased towards the plaintiff, the defendant, or if it's a criminal case, towards the state or towards the criminal defendant. Once we select the jury, the trial actually begins, right? And what happens with the trial, the first step to the trial is what is known as an opening statement. If you've taken me for constitutional law and mock trial, you are familiar with this. And the opening statement is basically given by both sides in a trial, where they outline what they think the trial is going to look like, the preview of the trial. They're not allowed to make any arguments. They're just allowed to say what they think the facts of the case are going to be. The plaintiff starts with their opening statement first, and then the defendant goes next. If it's a criminal case, the state goes first, and then the defendant goes next. After that, we have what are known as the different types of cases, the plaintiff's case and then the defendant's case. All right. And when the plaintiff goes up first, after both sides have given their opening statements, what they're going to do is present their evidence first through witnesses and documents. And the other side is going to get a chance to ask questions and cross-examine, meaning they're going to be allowed to try and see if the witnesses that the plaintiff has brought up are trustworthy or if they're biased. But the plaintiff is going to go through their witnesses who are hopefully going to provide evidence for the plaintiff showing how the defendant broke the law. Once the plaintiff has brought up all of their witnesses, and by the way, the same process goes for criminal cases for right now. So you would just replace the word plaintiff with state, and you would see the exact same outline for a criminal trial. But once the plaintiff has called their witnesses and introduced all their evidence, they will rest their case. You've heard the term before, I rest my case. That's what we're talking about, right? That's what we're talking about. So once opening ends, the plaintiff does their case. Once plaintiff finishes their case, they rest their case, and now the defense gets to provide their case. And they're going to do the exact same thing the plaintiff did in terms of bringing up their own witnesses that will hopefully show how the defendant did not break the law or poke holes into why the plaintiff's arguments are not right. And the plaintiff is also going to get a chance to ask these witnesses questions to see whether they're being trustworthy and attack their credibility. Once the defense's case rests, we've already finished 3 phases. The opening arguments, the opening statements, the plaintiff's case / state's case, and the defendant's case. Now we go into what are known as closing arguments. And closing arguments are where each side gets to argue to the jury what the entirety of the case was about and how the jury should analyze the evidence to return a verdict of liable, if you're the plaintiff. That's what you're going to say in your closing argument. Not liable, if you're the defendant, in a civil case. Guilty is what you're going to ask if you're the state in your closing argument, if it's a criminal case. Not guilty if you're the defendant in a criminal case during your closing argument. So that's what the purpose of closing argument is going to look like, to actually make your arguments before the jury as to how the jury should decide the case. After closing arguments are made, the jury is going to actually sit and discuss whether they believe a law has been broken or not, and they're going to decide what facts they believe. If it's a civil case, the jury must believe that it is more likely than not that the defendant broke the law, meaning the defendant is liable, to the plaintiff. They just have to believe the plaintiff a little bit more. If they do, they have met the burden of proof. The plaintiff has met the burden of proof, which is preponderance of the evidence, and the defendant is found liable. In a criminal case, on the other hand, it would be different terminology. It would be called beyond a reasonable doubt, and it would be a much higher burden of proof. What happens if the jury can't reach a result? What happens if the jury cannot come up with a verdict and they have no idea how to resolve the issue? The jury is said to be deadlocked. There is a mistrial, and typically, if nothing else can happen, they're going to ask for a retrial if there's a mistrial. Now, typically, the judge is going to do everything within their power to try and convince the jury to find a way to reach a verdict, reach a decision. Verdict is a word for decision. But if they're unable to do so, there's going to be a mistrial. If the jury does reach a verdict, then the judge is going to submit the judgment of the court, which means this is what the jury decided, this is the jury's verdict, and this is what the judge has decided is the consequence for the jury's verdict. After that, the losing side has the right to appeal if there is a legal mistake, which we already talked about that in the previous chapter. And that's pretty much it. I don't really care about execution. Once a lawsuit has been won or decided, the party cannot file that same lawsuit again because of what is known as res judicata, which means that once a dispute is litigated and resolved, the parties cannot bring it up again. It's been decided. I do care about res judicata. I don't care about execution. And that's it for this chapter. We finished the chapter. Email me if you have any questions, and we'll go from there. Stay safe, everybody. See you guys next week. Bye.